you can, you won't, and you don't stop. Or when you can, you won't, and you don't stop.
Might be coming out for sure.
We've looked at the doctrine of precedent. What we've got to do now is look at both sources of law, legislation and case law, and go a little bit more depth about where they come from and how we can find them if we want to work out what the law actually is. You'll remember that we have two sources of law. The first is made by Parliament or the legislature, and it's called an act or a statute or legislation. Those words mean the same thing. Parliament can delegate it to another body. Delegated legislation, they're often called bylaws or regulations. So that's one source of law. The second source of law, as we've learned from the doctrine of precedent, is common law sense 2, case-made law. That's the recorded decisions by judges. So what this means is whenever we have a law in this subject, we need to be able to reference that law. It either needs to be referenced to a section in Act, if it comes from one, or a case, if the source of law is a case. Okay? If there's a conflict between legislation and case law, legislation prevails. And that's based upon the idea that the law made by the legislature is made by our elected representatives. That should overrule decisions made by unelected, but only where there's a conflict. There are some areas of law made up almost entirely of cases, like contract law. The basis of that law has evolved over time from judgments that have been made. Now, in certain instances, that's supplanted and supplemented by legislation. For instance, consumer guarantees are inserted into contracts that a business might have with consumers. Unfortunately, we don't get to do consumer law, but that's an example of where statute is supplanting and supplementing essentially a case law system. There are other areas, however, that are really just rely on legislation, where the basis of the law is legislation. An example of that, say in Queensland, is the criminal code. So they've codified crime in Queensland to the criminal code. That's an example of legislation. Consumer law, again, is an example of legislation to cover a specific instance. Now note, though, that in this case, the judges then go and supplement the legislation because they have to interpret it. So, for instance, in consumer law, there's something called misleading and deceptive conduct. But what does that mean? And that is something that judges formulate. They formulate a test to work it is. So while we present things as though the two sources of law are different, they actually interact because judges have to read and apply the legislation, and the legislation supplements and supplants cases. And what we really get is a mix of these in modules 7 and 8, where we deal with negligence, where some of it, like for instance, whether you owe a duty of care, is based in cases, but the tests for whether there's been a breach of duty or causation have actually now been codified and put in statute. And so the two need to be applied at the same time. An important consideration is that just because there's legislation doesn't mean that the existing case law goes away. It just prevails in the sense of any conflict. So for instance, we're going to come to later in the course directors and officers' duties. There's a lot of legislation on that now under the Corporations Act, right? However, there's also a lot of case law that developed before the Corporations Act, and that's still valid as long as it doesn't conflict with the Corporations Act. It's just often that it doesn't get used because it's easier to use the legislation. So another way to think of that is case law is the safety net underpinning gaps in legislation. It fills in the gaps if there is no legislation. But where do we find this law? Well, there's lots of different sources, primary sources and secondary sources. For this unit, we're going to mainly concentrate on those primary sources of law, the actual piece of legislation or the actual case. Now, we won't read a lot of them directly. That's our reference point. If you're in any doubt, that's what we can go back to. So we need to start becoming familiar with the naming conventions that are in place around the law. So in terms of legislation, what we'll typically quote is the short title, okay? In this case, the Corporations Act, right? It'll have a date, and it will also have the jurisdiction, the Commonwealth. So if it was in Queensland, we'll see this. And a different date, it might be 1893, it might be an old piece of legislation, etc. So from that, we can kind of tell what it's about, the Corporations Act, when it came about and where, what jurisdiction. Case law, a little bit harder to interpret. There's a bit going on. So we have the two parties, okay? In this case, a very famous case that we'll come to in negligence. We have Donahue and Stevenson. Notice this is and. It's not versus, it's and. It's Latin, actually. And if it was criminal, we'd use the word against. So we never use the word versus. So it's Donahue and Stevenson. I'll probably get that wrong, but technically. Donahue and Stevenson, 1932, so we've got a date. The law reports. This tells us which court. Because different courts have different law reports. So this tells us it's appeals cases, UK, a high up court in the UK. So we've got a date, where it's from, and the page number. Okay, so it tells us a lot about what's going on. In fact, even the parties can tell us if we know where it is in the litigation process, because the first party is always the party who's bringing the case. And the second party is the party responding/defending. So if this is the first time the case has been brought, Donahue will be the plaintiff and Stevenson will be the defendant. That makes sense. Or if it's an appeal, Donahue will be the appellant and Stevenson will be the respondent. So it changes when you're appealing, because you're appealing and responding. But you will always, there's only ever in any series of cases going to be one plaintiff. So if the plaintiff loses and they bring it to the next highest court, they'd be the plaintiff appellant. If the plaintiff wins and the defendant brings an appeal, they'd become the plaintiff respondent at the next issue. Okay, so that's the naming. Most of the law you can find online at sites such as these. I actually tend to, for Commonwealth legislation, use Ostley a lot. I like Ostley in terms of searching and finding it, and it's really worth you going in and having a look at that. And we'll try and do that as some of the work that we do actually in class. Now, most people tend to find a statute easier to understand case. That's because it's pretty straightforward. There's a title, then the legislation is set out in sections. So it's pretty easy to find what you're referring to. We refer to a piece of law by its section and short title. Most acts will also have an objective section. It can also be divided into chapters. A case is more difficult. The judgment of a case can run from anything from half a page to more than 500 pages. How many judges are there involved? How complex is the case, etc.? All this comes into it. When a judge makes their decision, they give the decision and explain how they reach the decision, right? That's where the ratio comes from, the law comes from. But if there's more than one judge, each judge can give an individual judgment and they may not even agree. So after a case, it may not be clear what the actual rule is out of a case. Very famously, in Salomon and Salomon, one of the first cases that deals with whether a company is a separate legal entity, that's exactly what happened, and it took decades for that to become clear what the actual rule was. So what you need to understand, if you want to understand the law in a case, you need to understand the ratio decidendi of the majority, and possibly the counter-arguments if you're going to argue it, right? So this is a typical piece of legislation, Competition and Consumer Act. This has been separated into chapters, this one. This is the actual long title, an act relating to competition, fair trading, consumer protection, and for other purposes. Its short title, how it be referred to, is the Competition and Consumer Act. And here are the sections, section 1, section 2, section 2a. Okay? And here in section 2, we can see the objects. So it's pretty easy to find like a section and read a section in an act. What we have here is a case report of the Mabo decision, the one that inserted Indigenous land rights into the Australian system, native title. High Court of Australia, we can see the parties, the plaintiff, defendant, the year that it occurred. We can even see the judges who were hearing it, and we get the summary of the facts that were occurring. We've got the decision, the ratio decidendi coming through here, and this is just a summary without the judgment. Some authorities for some obiter dictum, cases that weren't followed but considered, some sayings by the way. So as you can tell, that was just the summary of what was going on. Now look also, a thing that's worth looking at here is we can see that different judges are saying different things. So look at this held, so it means they decided, held by Chief Justice Mason, Brennan, Dean, Toohey, Gaudron and McHugh, with Dawson dissenting. Okay, so we had someone not agreeing. Okay, then we have 1, 2, 3, 4, 5, 6, then we have 6 judges saying that. Then we have 3 judges saying this. Then we have 1, 2, 3, 4, 5, 6 saying this again. So not all the judges are agreeing with all the points. And the key thing to consider here is that means we're not really 100% sure what the law means. I mean, obviously 6-1, it's pretty clear the way the High Court is going. But if only 3 justices think this, how certain are we of that is the law? And it may take another decision or two where that gets considered before it becomes more certain. And so they're the key sources of law. That's what the law actually looks like in its primary form. And we've also been through some of the ways you can find it, or at least we've pointed you to the websites to where you can find what the law is so that you can read it yourself. Key thing to remember, it's much easier to find the law and probably understand it in terms of a statute than a case. Reasons is that in a case, the judges may not even agree as to why they came to the decision that they actually did, and that the rationale or the ratio, the reason for a decision, the rule, the legal rule will evolve. Up next, we start looking at the intersection between statute and judge-made law when judges have to interpret the statute, statutory interpretation.